completed his undergraduate studies at Stanford and received his degree from the University of Wisconsin. He only received his degree because he was able to throw the cane over the goalpost and catch it, right? You
yeah.
caught that? Okay. If you don't catch it, you don't get your degree, right?
No, it's if you catch your cane, you will win your first case.
And did that happen?
It did indeed occur, yes.
Okay. John worked in private practice for 5 years before joining the legal staff at the DOT. Since 1990, he provides legal advice to the agency in a wide variety of topics. And I can attest to that because we are in contact with him almost on a weekly basis. So he does a lot of stuff with motor vehicles, providing counsel to DMV, and also with eminent domain traffic laws. So please welcome John Sobotik.
Thank you. I should let Pam and Bob know that I too attended the University of Wisconsin at Platteville. After law school, I took accounting and computer science down there. I started out my practice at a firm in Platteville, and an unmarried young man with nothing to do in the evening thought it would be a good idea to go over and meet girls at the university. So I took some classes, and so there you were. Yeah, I found that out. Didn't work out all that well for that, but it did work out well. Accounting was a great class. Legal foundations of access management, and I'm going to put I think I'll see if I can find my glasses here, because I think I'll need them if I look down at the screen down here. And a lot of what we'll talk about today is the same. I'll talk about in here is going to be very similar to what we were talking about in the general conference this morning. So what are we trying to do? We're trying to give you folks a better understanding of access management laws, rules, and regulations. Oh, that might be the trick. This is probably my other one. This is mine and not the, okay. And help you distinguish between the possessory rights of government agencies, subdivision enforcement rights, and regulation of access under the police power. And just to kind of give you a general knowledge of the legal principles that are involved. Drew Jelinski did a great presentation yesterday. If you didn't get it, I think it's going to be on YouTube. You can look at his materials too. He talked about handling unusual access management situations in the toolkit. I'm not going to re-plow the ground that he went through, but it was a real good discussion of how to identify the access management tools applicable to a particular parcel of property or development, and we talked about that to some extent this morning as well in the general session. In general, you're going to want to check the record title for properties, right? See what deeds are out there. See if you already own the access rights. Check subdivision plats, survey maps, dedications, because you may find people with CSMs and certified survey maps, and with subdivision plats, often there are dedications in them. And if there are, great. Can I just ask, how many of you are from Wisconsin in this room? Okay, and the rest of you, where are you from? Pardon? Iowa? Arkansas? Illinois? And no Californians or Coloradans in here, okay? Pardon? Kansas, there we go. No constitutional takings clause in Kansas, we learned this morning. So, pardon? I heard that too. Yeah, it surprised me. My familiarity obviously is going to be mostly with the Wisconsin laws, and we'll talk about those, but I think most of this is generally applicable. Police power activities by governmental units is the last thing to check. Does the state, the county, the local government already control the access where you're thinking about imposing access controls? Pam disappeared on us, but I've run into more than one situation where, Dane County or another county they have their own access control provisions. They've already got access control in place. My guys come along and want to buy access under eminent domain or want to restrict it in some fashion. I'm like, why are you doing that? The county already controls it. Just get into some kind of an agreement with the county that they won't change it, and then you don't have to buy it from anybody and save your money. So let's talk about a historic context, and I talked about this a little bit this morning. Condemnation of lands for highways is probably the oldest use of eminent domain in the country, or one of them. I mean, the other purpose that it was used for, the other thing that it was used for was military purposes in the early days. And until relatively recently in the United States, most lands were bought in easement. I think Jim said this morning it was the mid-1940s where things changed over and we got authority to start buying land in fee. And I talked about this morning about the difference between having an easement interest in land where the servient estate, that underlying fee owner, is going to have a right to come onto your easement and use it, and owning fee where that right isn't necessarily there. It's interesting how that all developed. In England in the old days, right, what we talk about highway, right? What's a highway? What is a highway? No answers, right? Under English common law, it developed any public way as a highway, okay? Not only places where cars drive, but places where people walk. Railroad corridors were all considered highways under the common law, and you still see that reflected today in Wisconsin law. If you look at the definition of highway in Chapter 346 and the definition of highway out in Chapter 990 in our statutes, it'll say a highway is any public way. And in England today, it's still that way. In order to preserve highways and keep footpaths from being lost by non-use, there are actually clubs in England that go out and walk all the footpaths through the farmers' fields that exist, that remain public ways and have been public ways for the last 1,000 years. And they still go out, and just to make sure that they can show that the highway, that path remains in public use, they go out and walk them and document that to preserve the highways. Traditionally in England, any roadway established by the Crown, by the government, was a king's highway, and any encroachment on a king's highway was considered to be an encroachment on the king, which makes it sound as though in the early days of English common law, the highway was dealt with almost as though they had fee. But English common law evolved by the late 1800s. When the government acquired a highway, they were considered only to have acquired an easement, because all you really needed for public use was the right to go over the land. You didn't need the land itself. And that was the theory of the Crown in those days. And of course, they didn't have quite the number of conflicts in those days that we do today. You know, you're talking about horse and buggy days, not high-speed 70-mile-an-hour highways. Most of our states follow English common law, but we have to remember, we don't have anybody here from New York, we don't have anybody here from Louisiana, but Dutch and French laws were different. Dutch in Holland and in France, the government, when it acquired a highway, acquired fee. And that carried over to New Amsterdam, which became New York, and carried over to Louisiana, which was French. So New Orleans, most of the streets, the early streets, were owned in fee by the state. And similarly, Wall Street in New York would be a fee, was owned in fee by the New Amsterdam government, and then became English later. So if you're in a state, if somebody from one of those states would have to be looking at when did we acquire this street, and how did we get it. Most of the states are common law easement states, and I just looked through Nichols quickly for a list, and I've got a bunch of them there. I don't know if you see your name on your state on the list there, and they're not exclusive. They're not exhaustive lists. I couldn't find an exhaustive list, and then many states allow fee takings for highways. Is there any? What does Kansas do? Can you take highways in fee in Kansas? Yeah, so and you're not on the list here. I think most states now allow it, but you'll want to know whether if you take fee, that makes a difference. And why does it make a difference? If you own all the title, then your neighbors don't own any rights in your land. And that's a general rule with fee. And I would say if you are acquiring fee title, and especially we talked about that case this morning where you're crossing new lands, if you put in your conveyance that you're not going to give any access rights when you buy the land, I think you're going to wind up not having to pay for access rights in the future. And the people aren't going to have an expectation or a right to enter your highway. With easements, you've always got this problem of the dominant estate, that underlying fee owner, having a right to use their property in a manner not inconsistent with your highway easement. And it's going to be, you can, I think, affect driveways, but whether you can close access off altogether is another story. And I think it gets much more problematic in that kind of a situation. If you don't want to pay, you're going to have to try to use the police power early and see what happens. And it may be that you wind up in an eminent domain situation where you try to close it with the police power and you find you can't, and then you have no choice but to buy the access. Okay. So we talked about this, the police power, we talked about that pretty exhaustively this morning. This is a quote from Massachusetts. The police power is very different from the right of eminent domain. It's the right to make, ordain, and establish all manner of wholesome and reasonable laws, statutes, and ordinances, with penalties or without, not repugnant to the Constitution, for the good and welfare of the Commonwealth and the subjects of the same. And I like this second quote. It's much easier to perceive and realize the existence and sources of this power than to mark its boundaries or prescribe limits to its exercise. So when we talk about the police power, in access terms, we think about our right to maybe deny a permit. But it's broader than that. It's that, the zoning capability that the local municipalities have, it's derived from the police power of the state, the right to do things for the common good. In most states, the rule is that an abutting owner's access to and use of an adjacent highway may be reasonably regulated by the government in the public interest. Okay, so you're going to use the police power to do that. Complete denial of all access will require payment of just compensation to the landowner. Okay, and that's going to happen. Why? Because if you turn a property off so that you can't get onto or off of it at all, the value of that property is going to be greatly diminished. So you got to provide a mechanism for people to get on and off of there. Complete deprivation of access will take all or substantially all value of property from the landowner. Or if you give them some ridiculous, unreasonable route to get access, you're going to face that kind of a problem, right? If the access you're giving them is unreasonable, you're going to have this huge valuation problem with the property. And that's when you're going to look at potential taking under the U.S. Constitution or the Wisconsin Constitution. Now, some states statutorily or by state constitution allow compensation for police power effects on property when a highway access is affected. Okay, and those are the damages states. And you have to look at the individual state constitutions. And Jim put this slide up earlier today, talking about the 48 states that have takings provisions, and how do they come out? And what do these look like, damages provisions by states? And even the damages clauses vary substantially. Minnesota says lands taken for a public way, a fair and equitable compensation shall be paid for land and for the damages arising from taking it. Okay? And compare California, where it says private property may be taken or damaged for a public use only when just compensation is ascertained by a jury has first been paid into court or the owner. Okay, so you've got, it's got to be damaged. It's damaged for any kind of damage can result in compensation potentially. In Kentucky, no man's property shall be taken or applied to public use without just compensation being previously made to him. Okay, so the constitutions vary And you have to talk with your own lawyers and your own folks about what your law in your state says. All the states, like Jim pointed out this morning, are subject to the U.S. Constitution. So if it's a taking under the U.S. Constitution or it's a taking under the Wisconsin Constitution, it's going to be a taking in your state. We can pretty much guarantee you that. Okay. Typically non-compensable police and power acts. These are all things, even in the damages states, the tendency of the case law is to differentiate between damages to the individual property and kind of things that affect the community as a whole. So typical non-compensable police power acts: median openings, speed limits, highway permitting, subdivision regulations, setback requirements, where the highway is going to be located, changing of grade, reduction of visibility. Those are typical police power actions. And we generally aren't paying compensation for these kinds of things. Now, in any of these things, you may have a statute that provides something different. So in Wisconsin, for example, we actually have a damages statute that applies where we change the grade of a highway. So even though we may change the grade of a highway, that would be a police power action. We've got a statute that says, Wisconsin DOT, when you do that, you have to pay compensation for essentially for fixing the property, whatever problem you caused on the property by changing the grade. For those of you from Wisconsin, I kind of group things together, right? We've got, and all states will have this, we've got general, there's our eminent domain statute that says DOT can buy lands for highway purposes. And then we've got a whole bunch of police power regulations. Our high control highway, access highways, some of you may have this. I can promise you all of you will have a statute like R8429 that says our interstates are controlled access, right? You can't build an expressway interstate. They have to be controlled access with grade separated interchanges. I can tell you you're all going to have something that controls access on your interstates, probably on freeways as well. Maybe not on expressways. And then we've got some other provisions in police power. And we have a requirement here when we improve a highway and we take out that entrance, that connection between the roadway and the private driveway, we have to restore that connection, typically. And the only time we wouldn't do it is if we had the permit revoked. And we've got this is our general permitting statute, which is really regulates digging in the highways. We've got an appellate process, and we've got actually an administrative rule that kind of interprets that, what the spacing and so forth should be between them. And then we've got more general regulations, land regulations on platting lands. There are statutes on doing subdivision plats and reviews of them. And then we've got, of course, statutes, 3206 governs just compensation. That's eminent domain, how you pay for it. And then we've got municipal police power activities and comprehensive planning, how highways are discontinued, what the rights are of abutting owners, especially on discontinued highways. We have here on access to a cemetery. It's a police power limitation. This one limits the state DOTs and local government's police power authority. We can't close the access to a cemetery. We can get them to, we can redirect it, but I cannot close off all access to a cemetery, period. Probably if I really needed to do that, we'd probably have to figure out how to build an access road or something like that. Our county has a controlled access highway statute, and our municipalities have controlled access authority under the state constitution and their home rule powers. So that's kind of how they go. So what are the types of access regulations? The strongest one we have is where we buy the access, right? We're going to go out and we're going to build our project, and we put right in our deed, we're acquiring from you maybe a 10-foot strip that we need for right-of-way, and we're buying all the rights to access our highway. When we do that, we own it. And under our state law, the way our courts read it, That's it for the landowner. He can't even come to us and apply for a permit anymore. Okay? Does that mean we don't hear from the landowner anymore? I see a head shaking. No. That's right. He'll still come in and ask for driveway. He can't make a permit application, and none of our officials can issue him a driveway permit application. What do we have to do if we want? And this can happen. Okay, I've been in situations where we bought all the access to this 160-acre farm parcel. You know, we bought it in 1961. It's now 2017 or 2018, and we aren't out in the middle of the country with this farm parcel anymore. We're now on the edge of the city, and Costco wants to build their new facility, or Menards, or whatever. Choose your big box, right? And we own all the access rights. What do we have to do in order to give them a driveway where we own all the access rights? It's a real estate transaction, right? And so in Wisconsin, what we would have to do is we'd have to appraise those property rights before and after values, with and without the access, and make them buy the access right back to us. Okay? It should be expensive. Given what we pay for access, if we would cut it off to Menards, I would hope that we would get paid pretty well for that. Okay. And just showing that. And we can wind up with it in another way. And it's just the other ways we can get it up there. Right? Somebody can dedicate the land to us by deed or plat. And if you represent a municipal government, if you're working for municipal government, you may see this more often than we do. Because it's very common in development, you want to build a subdivision here, you're going to have to dedicate the internal street network to the city so that there's streets built. You're going to have to dedicate them, you're going to have to build the internal streets. Am I correct? I've seen lots of heads nodding, okay? So dedication is very common. Again, at that point, you can own the access rights, and you can have those access rights donated. So what you might do is you might say, if they want to develop this big parcel up here, you might say, we're going to make you dedicate the access rights here, and we're going to give you, and you're going to have to build this road into your subdivision and then build all the connecting roads. Okay? Donation. As odd as it seems, I run into this every once in a while where somebody just, we'll give it to you. We'll give you the access right. If we want a driveway permit, we're willing to give it to you, and here's a donation. And that may lead us to be willing to issue a permit at a location. It's okay for you to do that. The Supreme Court has said that's not a taking. Demand some, access controls in return for, or demand a dedication in return for approval of a development plan. And even in damaging states, that's okay. Non-accrual to the abutting owner when the land's on a new alignment. I talked about that earlier. Reservation of access rights when property is sold. This one kills me, right? I'm sure all of you have run into this. The city acquires, you go to acquire a property, you put a new road in, and you wind up with this goofy excess triangular parcel on your highway, right? And now, you bought it. Maybe years ago you bought all the access rights to that land, and now the things have changed, and you actually had to buy the land itself with the new project. And what do you do? And after the project is over, you've got this piece of land that you don't need. The neighbors want it; they want to buy it, right? You have to be very careful, because what happens with property, we own the access rights, then we bought all the remaining rights in that property. When that happens, when you do that, for lawyers, what we call it happens is, we call it merger of title. Okay? Now all the rights are vested in the state. Not only the real estate that we bought in this transaction, but also those access rights that we bought 25 years ago. When I go to convey that parcel away to the neighbor who's going to buy it for usually a pittance, he's the only guy who can use it, he's the only guy that's got access to it. I have to make sure in my deed that I keep the access rights. Okay, if I just give them a deed to lot 1 of plat X, I just conveyed away all of lot 1 to X, on plat X, including the access rights to it. And then Bob's going to come to me and say, John, what did you just do? And we're going to wind up having to buy them again, or continue to refuse them under the police power.
John,
So,
before
yeah.
you do that, I see another one that may be considered in donation, access covenants.
Access covenants. Yeah, covenants are restrictions, right?
There's an agreement between us and the property owner that gives us an access right. Is that correct?
Well, I don't know what, a covenant is going to appear on deed, so it's going to be a real estate ownership, and generally it's going to appear in the way of, it's going to appear as a restriction. So, and that might be, you might demand one of those as a condition for approving a subdivision plat, for example. So that'll appear in the title record. Yeah, it'll be a real estate restriction, right? But yeah, I guess it would be a dedication by deed in that case, is what I would call it. Because you're going to get a conveyance from the landowner to the county saying, we grant you all the access rights to this parcel. Or it might show up in the plat for the subdivision, which is the way I see them most often. When you're approving a subdivision plat, there'll be a dedication right in the plat. It'll say dedicated to public use. And then the county or the local municipality will accept that dedication, which is the final formal step that's required in Wisconsin before that dedication.
So we have used them in conjunction with permitting as well as their
Okay.
form, an access covenant through permit form. Say they want to have 3 or 4 accesses and we only want them to have 2. We draft a covenant.
Okay, and
Restrict it to 2 access.
so your permit says you only get 2 access.
Not the permit, a written, recorded access covenant.
Okay, and so that would be a conveyance.
DOT form.
Okay, but that would be a conveyance. Okay. It may not say deed at the top, but that would be a conveyance. Yeah,
And that's not a real estate transaction if you were to alter that.
that is a real estate transaction.
A covenant is a real estate transaction?
Well,
We never, there was no.
okay,
It wasn't a
the
real
question
estate
is,
transaction.
the question is the covenant a real estate transaction? If you're creating an instrument by which some interest in the land is conveyed from one person to another, okay, you record it in the Register of Deeds office, so it's an official record, that's a conveyance. And whether the top of that document says deed, or it says easement, or it says covenant, I don't care what it says at the top, it's the conveyance from the landowner to the state or the city or the county of a property right. That's a real estate transaction.
The covenant doesn't convey. The covenant is simply.
It's a restriction.
We don't own the access rights in before, or we would already be done. The covenant is written when there is no ownership and we're making an agreement with the property owners. We're saying, you're gonna come in and do 2 permits, we're gonna agree to that. You're gonna sign it and say, come in, we'll give you 2 permits.
Okay, so
When they say we'll only have
just for the recording, what Sue just said is that our state DOT apparently issues these covenant documents in the permitting process, and they don't take a real estate interest by that process. So it's more of a contractual agreement with the permit holder. As a condition of your permit, you aren't going to get any more entrances onto the highway. So. Go over this stuff, which is, which we've already talked about, and talk about self-imposed private property restrictions. Deeds, subdivisions, CSMs. You want to look for these things. I've run into this more than once. What can happen? Property owners, when you subdivide property, there are all kinds of things that go on. One is there's going to be a subdivision plat, which may have a dedication on it, right? Another thing that's very common is there are what are called mutual property restrictions in the deeds. Okay, so there'll be a group of subdivision rules and regulations essentially that apply to that subdivision, and they create enforceable private property restriction that exists between each owner of a piece of land that's bought in that development. So, for example, in the property that I own on the west side of Madison, there's a provision in the subdivision documents that says I can't build a shed on my property. Okay, and what they give every person who's in my subdivision has the right to sue me if I build a shed on my property. Okay, well that's not going to matter for access, but mine also says that I can't open any commercial establishment on my property. Would that matter to you if you're trying to figure out whether to issue a permit for a store on my property? My broach is shaking and said yes. Okay, so you'll want to look at those kinds of things. They may not have the ability or the authority under the deed restrictions in place to do the use that they're contemplating doing. Okay, and I would think under the police power, I would say we're not going to authorize a permit for the purpose you're saying because you've already got a private deed restriction that says you can't do that anyway. We're not going to frustrate all your neighbors by issuing a permit for something that you're not allowed to do. If you want to do that, you're going to have to get your private deed restriction lifted before we're going to issue a permit for that purpose. Okay, so you're going to want to look at those as well. Condominium documents, subdivision, and CSM restrictions are very common. I had a question. Yeah?
So you're suggesting that we look at deeds on, or every time somebody requests a permit?
Well, if you, look, if this is routine and you're not worried about it, then, and you're going to issue a permit anyway, then maybe you don't care. Okay? Well, you know, in general, when we're talking about access control, we're talking about places where we do care, where we've got concern about issuing a driveway permit in this location. And should we issue it or shouldn't we issue it? How do we control that access? What's appropriate to do and what isn't appropriate to do? I'm just saying that this provides you another thing you can look at to help you decide what to do.
Now, you require a copy of the deed with permit application.
So
We do.
Bob asked, do you request a copy of the deed for the property with your permit application? And Bob is saying, here in Wisconsin we do, maybe in Kansas you want to do that. We try to get those, at least some of the title records so that we can tell what's going on. And if I see that it's part of a subdivision, I'm going to say to the property owner, hey, I want the subdivision restrictions too. Send me your subdivision restrictions, whatever they are, your condominium agreement, so I can see what the restrictions are on your property. Let's see, what's going on. All right, police power regulation and design. So access control through subdivision planning, I mean, we already talked about this in Wisconsin, it's chapter 236. Municipalities, you get to approve subdivision plats if you're a municipality. I think this is going to be the case in most places in the country. In Wisconsin, we have what we call objecting authority, and we actually have rules related to what we do. But essentially, we have the ability to say, okay, you're going to develop this parcel. We get some say in how you connect up to, or how these roads are going to connect up to our highway. And we can object to the way, you know, we don't like this particular drawing, we might make them change it, so we might say, no, you don't get to do that, you need to come in back here. Or maybe you don't have enough site distance at the place where you want your driveway, we want you to move it over there. Yeah.
The usual objection I see is, look, you don't have 4 entrances on the highway, provide for internal circulation.
Right.
It's a really obvious.
Right, so Jim is saying, just for the record, what Jim Teal just pointed out is the usual one he sees is you've got a parcel of land and they have 4 properties cut up along the roadway and they want 4 driveways. And we'll say, no, that's not the way it's going to work. We'll give you 1 entrance at this spot and then you provide internal circulation to your 4 lots or your 10 lots or your 20 lots. We don't want everybody getting their access off of our highway. And that's perfectly appropriate. I think with 4 lots, we wouldn't be looking at a subdivision. in Wisconsin. Right, and here in Wisconsin, we've got a statutory scheme that says we have to, we can't, we're an objecting authority. So we get to, the state has to approve. In fact, DOT is the approving agency. We file objections with our Department of Administration. Other agencies that have rules and they can file other objections with the Department of Administration. And that agency in this state makes the final decision on, whether they're going to approve the plat or not approve the plat. Generally, if we say we don't like the highway entrances, they won't approve the plat until they see a plat that we can agree with. And that's the way we do it here. Municipal government role. 23610 here in Wisconsin requires municipal approval of a subdivision plat. The city can require water utilities. They can require payments by the developer. They can require installation of highways or control of access by the developers. Municipalities have a lot of power in this area. Okay? And that none of that is going to amount to a taking. So you don't pay for it, you just do it through that platting approval process. And I think I talked about this earlier. Even though California is one of those damages states, requiring a dedication of land for highway as a condition of subdivision approval does not constitute a taking. Okay? Connecticut, where the required to set land aside results from a developer's activity, there is no taking. Okay? Illinois, a municipality may require a developer to provide the streets which are required by the activity within the subdivision. But they can't require them to provide a major thoroughfare. You want to build an expressway through the subdivision lands. No, you're going to have to buy the lands and build your expressway. But you can make the developer in Illinois provide the streets for that subdivision. I love this one from Kentucky. It makes no sense to allow one to develop property in a manner as to increase traffic on abutting its street and then require the government to condemn part of the property to provide an adequate thoroughfare. Dedication requirements as a condition precedent to plat approval are not an unconstitutional taking. Okay? And we see similar findings, similar rules across the country. I listed some of the states there that just jumped out at me when I went through Nichols. So, access restrictions affect all properties in the subdivision. So, and that goes back to the mutually enforceable covenants. Not only does the state generally have a right to enforce them, but in addition, the landowners have them. And then each state or municipality should have either statutory rights to enforce such restrictions, or maybe you create those rights by contract with the developer and inclusion in the real estate documents. If you don't have a statutory right to enforce the subdivision plan. In Wisconsin, what happens is when if the state, for example, isn't going to be one of the landowners in the subdivision. Okay, and ordinarily the general scheme of the law is that when you divide land and you have mutually enforceable covenants between the parcels, any one landowner in the subdivision can enforce those restrictions against all the other landowners in the development. Well, where does that leave the state? What's our right to enforce? We don't have one as a landowner in the development. The municipality wouldn't have one as a landowner in the development. Although maybe you could argue that if the streets are dedicated to now a property owner in the development, you have that right. States generally not going to have that. But we have enforcement rights in our statutes that are granted under Chapter 236 to enforce those subdivision restrictions, even though we're not a landowner. And that's, so we don't have a real estate right, we've got a police power enforcement right to go out and enforce the private property restrictions that are put on there. Generally, if you're restricting ingress and egress under a permitting process, it's not going to be a taking. Arizona, a municipality has the power to regulate the use of its streets, including ingress thereto and egress therefrom. Okay, Ohio, the legislature may, in the lawful exercise of the police power, regulate the right of ingress and egress without compensation, so long as there is no denial of ingress and egress. Okay, so even in states that are damages states, you still have police power ability to control that access. Virginia, reduction or limitation of direct access to an abutting landowner's property generally is not compensable. And what's the exception? When is it compensable? When I leave them with no reasonable use of the property. That's right. That's our standard. Okay. Highway design decisions are also police power control. Installation and the use of median openings, allowing U-turns, eliminating on-street parking, one-way street designation, installation of curb and gutter, safety island installation. That's all police power activity. Should not be paying compensation for those things. I think in one of the examples we looked at this morning was the G&E parcel, which was in Wauwatosa, and it was the one with where the people had to go around into the alley to get to the property in the after effect. And in that case, they also argued we actually closed the median opening for a street, for the street immediately north of the property. We closed the median opening there so that the whole street, Garfield Avenue, became right in, right out. And the landowners argued that our closing the median was taken from them. And the court said, no, that's police power. That's designing the highway. That's what the state does. It's the state's highway. It's the state's land. It's the state's decision. And when it came to where they left with unreasonable access in which was the standard right in our permit denial case, we revoked their permit. We can't revoke the permit if we don't leave them with reasonable access. We pointed out that people could just make a right and make a U-turn at the stoplight and go south. They didn't have to make a left turn directly out of Garfield Avenue. Similarly, southbound traffic could go past Garfield, make a U-turn and come back and get to the property. And it amounted to a few seconds time. The hearing examiner thought that was perfectly reasonable and justified given the safety considerations. And you see similar holdings in other states. Here's one from Virginia. They widened a highway from 2 lanes to 4. From 2 lanes to 4. They didn't give a median crossing for the landowner. The landowner said, "Hey, I can't turn left out of my property anymore. I'm entitled to compensation." Virginia said, "No, you're not going to get any compensation for that police power." So it's pretty standard across the country. Here in Wisconsin, we talked about this already this morning, but we have this special statute that gives us, 8425, that gives us the right to put controlled access highways on our controlled access on some of our non-freeways. I was talking to Phil Demosthenes this morning, and he told me that Colorado actually passed a law making all of the state highways controlled access. So don't we wish we had that in Wisconsin? Life would be much simpler. There's something that Wisconsin guys can go to the legislature and ask for. We also have interstate and expressway controlled access statutes. Obviously, freeways, you're going to only get access at the ramps, at the interchanges, and your state's got to have this. All the states are going to have this. So, and that's all police power. You're not going to you shouldn't be having to buy access there. Now, in our statute, what happens? Let me go back. When we decide to make something a freeway or expressway, and we're buying it, and we're going to put access on this way, what we have to do, our statute requires us. It requires us to put in a frontage road, and so they will continue to have access in the after condition. Again, in Wisconsin, our most common police power control is with just general permits, which the state issues under 8607, municipalities will issue under their authority, and I'm sure your state will have a similar rule on issuing permits. Just the fact that we have the authority to control digging in our highways and modification of our highways gives us the authority to permit or not permit that activity, and that gives us authority to just say no, which is what we have to do when we think the driveway's in a bad location. Sometimes we can fix that by talking to the landowner and saying, "Hey, we can't approve it here, you don't have adequate site distance, but move it down to this other location and we can approve it." Sometimes we say, no, you just can't have a driveway here. You have to come off your side road. Typically, if they have a side road, we make them come off the side road. And we talked about this earlier as well. The general rule is that damage resulting property through the exercise of the police power is not compensable. And then, you know, this is a great example, Commonwealth of Kentucky versus Carlisle. A great example of how not to try a case like that. They get to trial, and the state didn't bother to object to any evidence of all the damages caused by all the police power activities. Right? They're changing the median, they're changing the location of the roadway, all the things that they're doing under the police power. They didn't object to evidence related to that and damage assessments related to that going before the jury. The attorney was asleep at the wheel. Well, once it went into the evidence, then the jury considered it. You know, the state was found to have waived its right to object, and when they got a big damage award against them, it's too bad, so sad. Next time, do your job. Don't let all that evidence go to the jury. So, simplifying issues for litigation. I think confusion can result from combining police power action and eminent domain at the same time. And we had some examples this morning of, you know, this thing where, okay, taking that strip along Highway 41 is a separate action from rearranging Maple Road going north and south and putting in your overpass. And that's separate. Because they're separate, we'll consider them separately, and we won't assess damages for the changes that resulted from straightening Maple Road. Right? We saw that this morning on one of in the Chance example. Well, yeah, okay, great. We won that at the Supreme Court. As an attorney for my client, I'm going to tell them, I don't want to go to the Supreme Court to argue about those issues. Make it simple for me. You know, can you straighten that highway before you close the access? You know, what can you do to mitigate? What can we do ahead of time to eliminate the problem of doing both things at once? Can we do the police power activities ahead of the project? Or can we wait and do them after the project, see if there's a problem, and then do it later? Close the driveway later and make them relocated. Do you have to do it when you're buying land? If you don't have to do it when you're buying land, you can do it at a different time. It'll generally make things easier for your lawyer.
John, I have a question.
Yeah.
First of all, everybody in here might not have been at the session this morning. Okay. They were, but some might not have been. But I wanted to ask this question in the morning just to verify for people. When the attorneys say, if you can at all possible, don't buy land that you need for your highway project if you're going to also move the access and it's in that same location with the existing driveway. If you wish to move to the side road, happens to be where you need that strip of land to push out the curb and put the sidewalk in your design. Try to avoid doing that, and you're saying maybe do it a year ahead of time. I get why, but I don't get why. The reason is because it will go to a jury, and jurists get confused, they don't understand.
Well, when you're,
driveway was moved
anytime we buy land, and anytime we exercise eminent domain to buy land, we're going to have to put a price on somebody's property, and we're going to have to say, this is how much your property, we think your property is worth, and this is what we're paying for it. And those people have a right to appeal that amount. Okay, so they have a way to jump into court on you. Okay? Once they're in court, I can't tell you what Joe Judge or Joe Juror is going to do. If the judge is smart and can separate those things out, like you seem to be separating them out, great, we're all good. If the judge doesn't separate them out and lets it all go to the jury, or your attorney doesn't separate it out and lets it all go to the jury, that was the last thing I talked about, you're going to wind up making it easy, your actions made it easier to confuse the court or confuse the jury, and you're reducing your likelihood of not having to pay for it. Thank you.
So is there a legal implication of knowingly taking driveways, police power, knowing you have a project coming through, it's gonna have eminent domain.
Okay, so the question I'm getting is there a legal implication of knowingly taking driveways, knowing there's eminent domain? I am not suggesting you take driveways. I am suggesting you regulate access, okay? If we take land, okay, that's a separate issue entirely. Okay, and I'm not, and driveways in particular are not the thing that you have to worry about taking. It's access that you have to worry about taking. If you leave that property with no value through your police power activities, you're going to be subject to eminent domain, to an inverse condemnation action. You're going to have taken substantially all value of that property, and you're going to wind up with a taking. Okay, but if you come through and use the police power ahead of time, perfectly prudent. It's appropriate. Okay, and there's nothing wrong with doing that. Even though you might have a project that you're anticipating in a couple of years where you will be buying property, that's a whole separate issue. And when you come through and buy property, you'll be buying what's there at that time.
And we used to do that in Wisconsin at one time. We would put projects together just to go regular driveways. So there would be a backhoe with some equipment on this project to do such things. And then for whatever reason, we quit doing it. And it's really sad because now, like Kevin's saying, that we know we're going to have to move driveways on the side roads. We're also knowing we're going to need strip railway there. We would like to do it ahead, like John says, but we don't do those type of projects anymore. And I don't really understand why. It sounds like a great idea, but you need a backhoe. You can't just go do it. You have to put a plan together to do it.
Right. So for those of you that couldn't listen on the tape or on YouTube, what Mike was essentially saying is that here in Wisconsin, we generally don't have projects to go out and take driveways out ahead of the time that we do construction projects. Our history has been to do all this stuff at one time. And when we do that, there's a cost to it, and that is that we raise the confusion issue and we raise the likelihood of having to pay. And I would say that's particularly the case in the example, one of the examples that Mike gave us earlier is if I'm going to take a 10-foot strip of land in a project, and there's a driveway in the middle of that 10-foot strip, and I want to close that driveway, it's going to be very hard for me to argue that closing that driveway was not related to taking the 10-foot strip. I've got to convince the judge that those are separate acts. The judge is going to look at it and say, that's the same location. And I think you're going to wind up paying. Jim Thiel's got his hand up back there.
Yeah, I think maybe explaining the procedure would be helpful. When you take property, it's valued as of the date of taking. So if you've taken the driveway out a year ahead of time, before value before the taking is without that driveway.
Okay, hang on, Jim. You got to say this so they can hear it.
Yeah, if you take the driveway out with police power a year ahead of time, when you come to taking the 6-foot or 10-foot strip you need, the valuation of the property is as of the date of taking. As of the date of taking, there's already no driveway there. So it's already taken care of in the before value of the property.
Right.
So the other way, and I think this is what you were concerned, well, how do you keep that information from the jury if you did it ahead of time? Well, there's a practice called a motion in limine. You ask the court to make a ruling that any evidence of that will be excluded ahead of the time. And a good attorney will say, no, I'm making a motion. I want a ruling on this, judge, right now that there will be no evidence of those prior police actions.
Right. And I mean, the way this comes up in the trial context is you're going to have a before and after appraisal of this real estate, before the taking and after the taking, in order to come up with what are the damages from the taking. And I would object to any appraisal that includes a driveway that didn't exist at the time of the taking. So if their appraiser included a driveway in its estimate of the before value, I think I could get that excluded with the motion in limine. Unless I sleep on it like that attorney from Kentucky. Yeah.
So the answer is you guys got it figured out, and I don't know.
No, the answer is we keep having this discussion. The problem we still face is that even though we could legally revoke, we could do the police power ahead of time. As Mike said, we don't have a backhoe. What happens is the physical removal of the driveway gets added onto a project, so the driveway is not physically removed until the project, therefore it physically is still there on the day of take. That's what we face.
Yeah, that can happen too.
That's what happens to us.
But at that point,
They won't give me a backhoe.
And at that point, then the attorney is going to have to object and say it's not legally there and it shouldn't be compensated. Okay.
John,
Takeaways. We've only got a couple minutes, so I want to kind of close up.
Well, it might not.
Takeaways. Access can be acquired under eminent domain. State and municipal governments generally have the right to regulate access under police power. Counties as well, obviously. Access can be shared off side street or indirect through service drives. They don't have to have a direct driveway onto your highway in order to have access. I would avoid simultaneous application of police power control in eminent domain where possible, just to make eminent domain litigation simpler for your attorneys. I can give you a much better idea of what you're going to have to pay in damages if you don't combine them. When you do combine them, it's a bit of a crapshoot. Compensation won't be required when access to a property is altered under the police power. It's going to be difficult to separate if you're buying land where you're trying to exercise the police power. And of course, if you're not from Wisconsin, you're going to have to check with your attorneys about all of these rules because the laws differ in states, especially states that pay for damages to land. And how far you can go without having to pay is going to differ in each of those states. And it'll be governed by their case law and their constitution. Changes to the streets are generally not compensable, and I think this will be the case in all the states. Addition of curbs, closure of median opening, access to a relocated side street or alley. Next one is check existing property restrictions before you purchase access rights. Don't buy what we already own, or if the municipality already owns it, or if the county already owns it, or if they have private property restrictions, you don't need to buy it. Check those things. Next takeaway, these issues are complex, subtle, they're always subject to change, they vary by state, so don't assume that you know the answer. If you're dealing with a complex situation, get your attorney involved. Get them at your planning meeting. When we have big highway projects now, it's not unusual for one of the attorneys to be asked to come in and sit down, and we'll sit there with the plat and we'll go through each driveway and figure out how we're going to approach each driveway. Hey, do we need to take this 10 feet? Let's not take it because we're going to close this driveways. All we're doing is police power. We don't have any chance for that eminent domain appeal. Each case is unique. It has to be referred, taken on its own. And folks that helped prepare this outline, Mike Roach, Sobotik was here, Dave Nielsen, some of our retired folks, Ernie Peterson, Jim Teal back there, Kathy Batha. I don't know if Joel's in the room. Joel has been at this conference today, this week, and Drew. So just thanks to everybody who contributed to putting this together.